Section 26. Offers, documents, and disclosure mistakes that can cost you your license. Offers, documents, and disclosure mistakes that can cost you your license. Ashley had just finished one of the busiest weekends of her career. 3 listings had gone under contract. 2 buyers were writing offers, and her phone had not stopped ringing since Friday morning. As she walked into the brokerage Monday morning, she looked exhausted. Michael smiled. Busy weekend? Ashley laughed. I don't think I slept. I've got contracts everywhere. David walked into the conference room carrying a stack of files. Perfect, because today we're talking about one of the easiest ways for good agents to find themselves in front of ADRE. Ashley looked surprised. What did I do now? Michael smiled. Hopefully nothing. But when agents become busy, they sometimes begin making decisions that belong to their clients. Ashley sat down. What do you mean? Michael picked up a purchase contract. Arizona law is very clear. As licensees, we facilitate decisions. We do not make them. He explained that one of the most important responsibilities of every Arizona real estate professional is ensuring that transaction documents are delivered promptly and that clients receive every opportunity to make informed decisions throughout the transaction. The commissioner's rules require licensees to provide executed documents to the parties as soon as practicable and to promptly present offers received on behalf of their clients. These duties exist because the transaction belongs to the client, not the real estate agent. Ashley nodded. So I shouldn't decide whether an offer is worth presenting. Exactly, Michael replied. That's never your decision. David added, I've seen agents say, this offer is way too low. I'm not going to bother my seller with it. He shook his head. That single decision has resulted in disciplinary complaints. Michael explained that under AAC R428802, licensees are expected to deliver legible copies of executed transaction documents to the parties as soon as practicable. In today's environment of electronic signatures, secure document portals, and email delivery, clients generally expect to receive copies immediately after execution. While the rule recognizes that unusual circumstances may occur, delaying documents without a valid reason creates unnecessary risk and confusion. Ashley smiled. I usually send everything within a few minutes. Michael nodded. That's a good habit. It protects everyone. He then turned to another common issue. Offers. Ashley laughed. I've heard a lot of opinions about that. Michael smiled. You'll hear even more. He explained that Arizona licensees have a duty to promptly present all offers unless the seller has provided lawful written instructions stating otherwise. That includes offers that seem unrealistic, low, unconventional, or unlikely to be accepted. The role of the real estate professional is not to determine whether an offer deserves consideration. The client's job is to evaluate the offer and decide how to respond. David leaned forward. Think about it this way. What if that terrible offer becomes the beginning of a negotiation that ultimately closes? Ashley nodded. I've actually had that happen. So have most experienced agents, Michael replied. He explained that the same principle applies when multiple offers are received. Licensees should never delay presenting one offer while waiting to see if another arrives, unless they have specific written instructions from the seller. Every client has the right to make informed decisions based on all available information. Ashley asked, what about verbal offers? Michael smiled. Good question. Although written offers provide greater clarity and are strongly preferred in modern real estate practice, licensees should communicate expressions of interest consistent with their fiduciary duties and brokerage policies. If a potential buyer communicates terms that could reasonably develop into an offer, the listing agent should consult with the seller regarding how the seller wishes those communications to be handled. Good communication protects everyone involved. David nodded. The safest practice is simple. Never assume, never filter, never decide. Ashley laughed. So my job is to present information. Exactly, Michael continued. Another area agents forget is document delivery. He explained that buyers and sellers frequently believe they have received documents simply because they signed them electronically. However, licensees should verify that all parties actually receive fully executed copies of the final agreements. Prompt document delivery reduces misunderstandings, improves communication, and creates a complete transaction record should questions arise later. Ashley looked around the room. So the rule really comes down to communication. Michael smiled. That's exactly right. Communication, documentation, and allowing your client to make every important decision. David closed the file. The agents who stay out of trouble usually follow one simple philosophy. Ashley smiled. Which is? They never become the decision maker. They remain the professional advisor, and they let the client remain in control. Michael nodded. That's exactly how you protect both your client and your license. Real-world Arizona example. A listing agent received a verbal inquiry from another brokerage regarding a property that was already under contract. Believing the transaction would close without issue, the listing agent chose not to inform the seller about the potential backup offer. Several days later, the original buyer canceled the contract. The seller later learned another buyer had expressed interest and filed a complaint, alleging the opportunity had never been presented. Although every investigation depends on its specific facts, the situation illustrates why licensees should communicate promptly and allow clients, not agents, to decide how offers are handled. Broker tip: never become the gatekeeper of your client's decisions. Present offers promptly. Deliver executed documents without unnecessary delay. Document your communications, and when in doubt, involve your designated broker before deciding how to handle an unusual situation. Online discussion. Question 1. Why should a real estate licensee avoid deciding whether an offer is good enough to present? Model answer: because the client, not the licensee, has the legal right to evaluate offers and determine whether to accept, reject, counter, or ignore them. The licensee's responsibility is to communicate information, not make decisions on the client's behalf. Question 2. How has electronic document technology changed expectations for document delivery? Model answer: electronic signatures and secure document platforms allow executed documents to be delivered almost immediately. Prompt delivery improves communication, creates accurate records, and helps reduce misunderstandings. Question 3. What is one of the biggest risks when an agent becomes extremely busy? Model answer: busy agents may unintentionally delay communication, postpone presenting offers, or fail to deliver documents promptly. Good systems and consistent communication help prevent these mistakes.